If you do it again, we will not be here with anybody saying, let's give them medication, let's help them, let's put them in programs. I'm not going to hear it. If you try to contact or communicate her, with her in any way, you're looking at minimum 2 years up to 20 years in prison. And I'm going to take it very seriously. I can tell you that. Do you understand?
Absolutely.
So whatever the relationship was, it's done.
Yes, ma'am.
And there's no reason for you to ever talk to or communicate with her again. If you do, you'll go to prison. It's that simple.
Yes.
Okay. So I'm going to find that you entered your plea of true to count 1 freely and voluntarily, find that count true, find sufficient evidence to revoke your probation. I'm not going to do that. I'm going to continue you on probation. Again, same condition, not to have any contact or communication. Any issues, you'll be on the mental health caseload if you need any help with whatever it is. Probation's there to help you do that, okay? Yes.
I was wanting to ask you, if like I could have any access to like a mental hospital or prior release, like after I get released.
Talk to probation about that as soon as you're released,
Yes.
because they have options. And if there's something that they can find for you that's inpatient, it's hard to find some inpatient. There's outpatient stuff that you can do. You need to, but there might be something that they can do. You need to talk to them about that immediately, okay?
Probation officer?
Yes.
Okay.
As soon as you get out and you're released from custody, go straight to probation, make that appointment, talk to them, explain that you feel like you need some help up front, so that you can be successful later. And I'm sure they'll do everything they can to do that.
Yes.
Okay, thank you.
you.
Go back with the bailiff. And Jody, if you'll just make a note to let his probation officer know that,
Officer is not officer.
okay,
So,
that what he's asking for is, thank you.
Judge, could you pronounce the 45-day jail sanction in this case?
Oh, you didn't say that out loud when he was standing there. Y'all might have said ahead of time.
Yeah, we said it ahead of time. We said it was a 45-day jail sanction.
With credit
With
for any time?
Correct.
So there will also be,
He's still got another 2 or 3 weeks to get to serve.
right, yep. And Mr. Seeger, as the best you can, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can put your hand down. Will your client waive the formal reading of the motion?
He does.
So let's just go through that motion. Mr. Segrest, in cause number 25, DCCR 1836, I have a motion to revoke your community supervision. Shows that you were placed on probation May 18th of 2026 for burglary of a habitation, and that was a 10-year sentence that was probated for 10 years. Is that correct?
I thought it was probation for 5 years.
Shows 10.
It was 10. It was 10 years.
It was 10.
Yes.
I thought it was 5.
Okay, so it looks like it was for 10. And then it alleges that you violated your probation. The only count is count 1. It shows that you violated the conditions of your probation by attempting to contact the victim of the offense, Perla Munoz, through the smart communication messaging system at our jail, May 26th of 2026. And is that true or not true?
It's true, Your Honor.
Did you enter your plea of true to count 1 freely and voluntarily? Is there another?
He's right, Judge. It was.
Is it
10
5?
probated for 5.
Oh,
Okay.
till for 5.
Okay, well,
I had to
with
double
this,
check it 2 places and it's 10/5.
okay, thank you. Well, thank you for bringing that up. Does the state wish to amend that motion?
Yes, Judge.
Does any objection to
Okay.
that amendment? Okay, so 10-year sentence that was probated for 5 years. And did you enter your plea of true to count 1 freely and voluntarily?
Yes, Your Honor.
And did you plead true to that count because it's actually true?
Yes, Your Honor.
And so it's my understanding that you guys have reached an agreement, Mr. Smith and Mr. Lewis.
Yes, Judge. He's just started on probation. We would ask that the court admonish him that he cannot have any contact with his Munoz. And that we will we offer to keep him on probation. Make sure he's on the mental health caseload, stays on his medication, and has no contact whatsoever.
So, Mr. Segrist, I have a feeling we probably talked about this at sentencing, that you weren't supposed to have any contact or communication with her. And 8 days after you contacted her, or at least tried to, You are gonna end up in prison for,
Big judge.
yeah, so Mr. Seacrest, it was also part of that agreement or recommendation that you serve a 45-day jail sanction as a part of that for you violating the probation. So I am gonna order the 45-day jail sanction. I think you have some time left on that. You can have probation. If you can have them maybe go out there while he's there so that as soon as he gets out, maybe there's something in place, that would be great. Thank you. All right, you can go back with the bailiff. Come on up. Good morning. Are you Brad Thomas Thibodeau?
Yes.
And will your client waive the formal reading of the indictment?
He does, yeah.
Mr. Thibodeau, in cause number 25 DCCR 0542, you're charged with the state jail felony offense of criminal mischief, impersonating a public service. Is it impersonating or impeding? Hold on. Impeding, sorry, causing impairment or interruption of public communications. And that's from March 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I'm sorry. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes,
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney's office, you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. There would also be restitution in the amount of $1,848. Is that your understanding?
1,480.
84.
1,484.
84.
Y'all wrote 1848. What's the
All
amount?
right. 1484.
Okay. $1,484. Is that your understanding?
Yes.
Speak up, please.
Yes, sir.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thibodeau is not competent?
No, Judge.
What is the state's position with regard to waiving pre-sentence?
We've agreed, Judge. He has a 1999 delivery of controlled substance. He received 10 deferred on that. I don't have any indication that it did not successfully complete it, unless he does. And in 2016, he had 20 days on a criminal trespass. With the restitution determined, I have an address for the Windstream Communication Company on 2nd Street in Winnie. It's send it directly there, so I don't have a problem if you don't waive.
All right, so I'm going to waive the pre-sentence report, Mr. Thibodeau, and find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay the fine of $500 as well as restitution in the amount of $1,484, and to follow all of the other rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, found guilty of the offense, and sent to the state jail for anywhere in the range of punishment, which is between 6 months and up to 2 years. Do you understand? It's very important that that restitution get paid from the beginning. A lot of people think, well, I've got 5 years, I'll pay it later. I want you to make payments towards that restitution immediately. Even if it's a little bit every month, get it paid off, okay?
Yes, ma'am.
All right, thank you. Good luck to you, sir.
Yes.
That's the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. Hakeem Manuel Thomas. Good morning, sir. Are you Hakeem Thomas?
Yes.
And this is 25 DCCR 0843. Mr. Thomas is charged with aggravated robbery. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Well, Judge, as far as the defense side, we're not ready to proceed at this time. There's some supplemental discovery I've been made aware of that we're looking to get copies of. I I guess as soon as I'm able to get that, then I'll be able to assess it and go over with my client and, so we can prepare from there, but we're still getting.
What's?
Two things, Judge, if I may.
Mhm.
I had a vacation letter in for next week that I submitted in
Oh,
December.
okay.
I think maybe this one just accidentally tagged along with.
Well,
codependent.
and sometimes what we'll do is leave it on a pre-trial, and
Yes.
that way if something gets taken
Yes,
care of.
and it happened to be a good thing in this case, and Mr. Wilkerson's here, he represents the co-defendant. I've been working diligently with my investigators to try to get some rather large supplemental discovery from different agencies, not even in a county, DPS in Chambers County Sheriff's Office, video from there. They have sent all that. I received an email with a lot of that yesterday. There's also some things in Fort Bend with respect to older offenses. There's a continuous offense of Port Arthur that goes along with this. So I would prefer to try Mr. Wilkerson's client first. It is set on August 17th. I'll make sure both counsel has that discovery by this week, as soon as I get it all downloaded and get it to them in the appropriate format, but that's kind of where I am.
So everybody should have all of it this week.
Everything that's come in. Yes.
Okay. All right, so let's do this. I'm just gonna reset Mr. Thomas and normal reset on the trial docket. That gives, since you're on vacation, gives you plenty of time. And then Mr. Wilkerson's, obviously we'll deal with that, in about 3 or 4 weeks, which hopefully will give you plenty of time, Mr. Wilkerson, to go over everything, and we'll see where we are on that case. All right, you can go back with the bailiff, sir. No, on a, keep it on the trial. Stacy Tyler. Need. Are you sending all those dismissals on Reyes?
It's mine, Judge. I was told they've already been done.
Why are they on the document? Usually they don't show up if I've already signed it. Okay. Okay.
Bless you.
Bless you. Good morning. Are you Stacy Tyler? And will your client waive the formal reading of the indictment?
She does, sure.
Ms. Tyler, in cause number 26 DCCR 0800, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 30th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 15 years in prison, which means if we go forward, you'll be leaving your punishment up to me. I can sentence you to 15 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not. And then you could leave your punishment up to them if they found you guilty. If we go forward this way, you're waiving that. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Tyler is not competent?
No objection.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so we can get a pre-sentence report done. And then we'll come back later for that. Anything that you think is important for me to know, get that information to Mr. Lewis and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you.
Jim Meldred, Willridge. Yeah, what do we do? Where are we on this? Yes, we are.
The Chambers County case has finally been assigned to a prosecutor yesterday,
Oh, good.
so I was able to talk to them. They wanted some time to get with the state here to
Okay.
get some feedback.
So just a normal reset.
Normal reset.
And I did send that discovery to you,
Yeah.
right? Or not not via the normal channels,
Yeah.
but just through an email.
Okay, good. All right, you're Jim Eldrin Willridge. And so, Mr. Willridge, what we're gonna do, it sounds like the case in Chambers County has finally been assigned and they're getting some information on that. So what I'm going to do is reset your cases here. So they can, your attorney and the district attorney can talk with the attorneys over there, get all that information. See what we can work out, if anything, when you come back at the next court date. All right, you're free to go back with the bailiff.
And I think that next time, Judge, regardless of where we are, probably best to go through the motion in that way, especially since it's out of county. I'll be able to get those people over here and ready, but
For a hearing
will we
after
still
that.
have that one interim setting?
Yeah,
You
yeah.
don't need me to have it next.
No, no, no. At the next one, we can interplead.
Please.
And then if it's,
Okay.
if there's no agreement, then we'll reset it for sentencing and we can have whatever sentencing time we need after that.
Okay, I'll check.
You have plenty of time. Okay, so that's it on this docket. I know I've got 11 o'clock hearing. If you'll give me just a couple of minutes to take a quick break, we'll be right back.
Okay.
Huh?
We have a witness in this case.
And, okay, is it okay just to come up and do it this way? All right, sir, are you Byron Jamal Morris? And Mr. Morris was previously in court, entered pleas of true to counts 2, 3, and 5 in a motion to adjudicate on probation for the second-degree felony offense of burglary of a habitation. I've received an updated pre-sentence report. Have you both received and reviewed that report?
We have, Your Honor.
Yes, Judge.
Are there any additions or corrections to the report?
No, Your Honor.
Not from the state.
All right, and so, Mr. Smith, you've got witness with regard to other, allegations?
Yes, Judge, in relation to, count number 1, as well as.
Actually, Judge, count number 4. I think we're going to change our plan because he did admit to the probation officer that he was intoxicated, but on a different date than the arrest. So I think we can change that to a true.
So let me go through it then. So, Mr. Morris, you pled not true to counts 1 and 4. Count 1 alleges you committed that new offense of public intoxication November 6th of 2025. And in that case, you still want to remain with your
That's still
not true.
Yes.
And then count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. And is that true or not true?
Yes, ma'am.
It's true?
Yes, ma'am.
Okay, so I will change your plea in count number 4 to true. And Mr. Smith, you have witness with regard to count 1.
Yes, Judge.
You may call your first witness.
State Falls Officer Jensen.
Yeah, if you'll just kind of slide around a little bit. We'll just do this informally. Thank you, sir.
Right.
Good morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Would you state your name for the record and spell it for the court?
Officer Michael Jansen, first name Michael, Michael, last name Jansen, Jantzen.
And how are you employed?
I'm employed by the Beaumont Police Department.
And what is your occupation?
I'm a police officer.
How long have you been a police officer?
About a year and around 3 months.
Are you a certified police officer in the state of Texas? What training have you received to become a certified peace officer?
I've been through the basic police officer.
Can I ask y'all both to speak up? Your back's kind of to the court reporter as well. Thank you.
And what do you do? You said you're a patrol officer?
Yes.
What is a duty job description for a patrol officer?
General patrol, respond to calls for service, any number of calls throughout a shift. Could be honestly anything.
Okay. Were you working in that capacity on November 6th of 2025?
Yes, sir.
And about 11:38 in the evening, did you receive a dispatch?
Yes, sir.
And what, if anything, did you do as a result of that dispatch?
Immediately began operating my department issued patrol car in that direction and arrived on scene.
Okay. What did you observe when you got there? And describe for the court what location we talking about.
Yes, sir. 4705 Magnolia. It's the Swift gas station. You're dispatched there in reference to a person who was asleep at a game machine inside that gas station. We arrived on scene, entered the gas station, and observed a person asleep at the game machine. Attempted to arouse him by verbal stimulus. I then reached under his chest and provided a physical stimulus to his chest. He did not wake up. At that point, he woke up after a few more conversations between my partner and I, and he woke up, immediately smelled the smell of alcohol emitting from his broken person, observed bright glassy eyes, and as we stood him up, we walked him out, to the police car and observed the unsteady gait as well.
Okay. In your opinion, did he appear to be impaired or intoxicated?
Yes, sir.
And did you feel like that was from alcohol and or other substances?
Yes, sir.
Was he impaired to the point that he appeared to be a danger to himself and to others?
Being that the location is in a very high crime area in the city of Beaumont, I absolutely believe so.
And do you see the person that you encountered on November 6th of 2025 at the Swift gas station here in the courtroom today?
Yes, sir.
Would you point to him and identify an article of clothing that he's wearing?
An orange jumpsuit.
Gonna let the record reflect. He has identified the defendant in this case.
The record will so reflect.
And did you place him under arrest for public intoxication on that day?
Yes, sir, I did.
That's what it's just.
Thank you, Mr. Rojas.
So he was in a high crime area and that makes him a danger to himself or others.
Yes, sir. Being that he was asleep in that gas station, I've responded to several calls there for violent crimes. He was unable to be aroused by myself and another officer. I believe that somebody could have stolen any number of items from him or assaulted him or been a victim of any other
What was the original call for?
person asleep at a game machine.
Nobody said anything about anybody being violent or any fighting or anything like that, right?
Not at that time,
Okay. Was there ever at all during this call?
not during that call, no, sir.
Okay. And when you were finally able to wake him up, he wasn't argumentative or disruptive with you, was he?
He woke up as a person would, surprised that there was two police officers. I feel like that's a normal reaction. All of a sudden there's two police officers with their, presence right there. But I was able to take him in handcuffs immediately based off of that reaction. Felt for him.
And you said you did the chest, what's it called? The chest rub?
Like a sternum rub.
The sternum rub. Most people wake up immediately from that, don't they?
Yes,
Even intoxicated people.
general in my experience.
In your experience, do you know of any kind of what would cause it? But you said he did not immediately wake up from that. What in your experience would cause somebody to not wake up immediately from that? If you know.
Any number of intoxicants in their system.
Okay. Could it also be due to seizures, maybe?
I'm not.
You don't know about that? Okay. You'll agree with if anybody in a high crime area is in a little bit of danger, right?
Yes, sir.
I pass the witness.
Anything
No further
else?
questions, sir.
Any objection to Officer Jansen being excused?
There you are.
Thank you for being here, sir. Any other witnesses?
No, Mr. Judge.
Right, argument with regard to count one,
I can call Mr. Morris on that, Judge?
on count one?
Yes.
Sure, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, go ahead.
Byron, you heard the officer's testimony, right?
Yes, sir.
Okay, and you and I have talked about this before, about count one, right?
Yes, sir.
Tell the judge, were you intoxicated on that night?
No, sir.
Okay, why were you asleep on that night?
I think I had a seizure on the machine.
Okay, and you are prone to seizures, aren't you?
Yes, sir.
And in fact, I think that's in the updated PSI that you do have seizures and the probation department knows about that.
Yes, sir.
Okay, now the officer says he smelled some alcohol. Why would he be smelling alcohol on your breath?
All that I kind of remember was I might have had an open container in the car. But I really don't remember.
Okay, so you admit that you might have been drinking alcohol on that night,
Quite a little bit, sir.
but you don't think you were intoxicated?
No, sir.
And well, pass the witness, Judge.
All right, Mr. Smith?
So, Mr. Morris, you're saying that you had a seizure, and as a result of the seizure, you had passed out to the point that verbal stimulus and physical stimulus did not arouse you, correct?
Yes, sir.
Do you take medication for your seizures?
Yes, sir.
What do you take?
Careful.
How often do you take it?
Grams,
How often do you take it?
twice a day.
Twice a day. Do you know how alcohol affects that?
Not really.
So you have no idea what alcohol does to that drug. It's an anti-seizure medication. Yet you consume your medication twice a day and use alcohol at the same time.
Well, I don't drink like that, y'all, sir.
You don't.
No.
Well, you drink often because you were pled true to count 4, and you just admitted that you were drinking on the day that you were arrested. Right?
Yes, sir.
No further questions.
All right, any other witnesses with regard to count 1?
No, Your Honor.
Any others rebuttal or anything, Mr. Smith? At this time, based on the evidence that's been presented, Mr. Morris, I am going to find count 1 true. That you did commit the offense of public intoxication on November 6th of 2025. So with regard to sentencing, Mr. Rojas?
Judge, Mr. Morris has been on probation since 2016. I think his probation has actually expired since March. It appears that from March of 2016, he was doing well until that first motion to revoke was filed in October of 2020. Notable, I think, as you can see from the updated PSI, at that time, he had some support of both of his parents, who unfortunately passed away, I think the following year, 21, when Mr. Morris at that point was sent over to safety relapse in March of 21. And then it looks like at that point, his parents passed away. He went from March 21 to December of 23 until the second motion to revoke was filed based on a new offense that was ultimately dismissed. And that motion was resolved by jail sanctions and continued on probation. And that brings us to this new motion, which is filed from, I think in February of this year with the new allegations. So he's been on probation for 10 years. Other than this new PI, he hasn't committed any new offenses, even though one was alleged. That case was dismissed in 23. It's unfortunate, I think, that his parents passed away because it looks like they were the support for him. They were able to give him some guidance while he was on probation. He was doing well while they were alive. And even after they passed away, other than administrative violations and this new admitted drug use and alcohol use, which is serious. I understand those are violations of probation, but he seemed to be doing well until this new motion was filed. I don't know what we can do with him, Judge, because probation's expired. My recommendation, or I guess what we would ask the court to do is to let this time that he's been in jail serve as sanctions and let his probation expire.
Right, thank you, Mr. Smith.
Judge, I believe the recommendation probation officer is absolutely spot on. I think he's taken advantage of the court's leniency. We've sent him to safety twice. He's been in drop. He's done the moral recognition therapy. He has not gotten any benefit from all the programs that have been offered and completed. He blames the fact that he can't act like an adult because he doesn't have people to tell him what to do, but he's an adult. He shouldn't have to have people tell him what to do. He's been given every opportunity, and just letting it expire would be not justice in this case. We believe that probation should be revoked and he should be sentenced to time in TDC, understanding that he will get credit for the time that he successfully completed safety. So we would ask for a significant amount of time in prison.
Thank you, Mr. Smith. Mr. Block's here and you have your updated report. Is there anything else that you would like to add, sir?
No.
All right, thank you. Mr. Morris, Mr. Smith is absolutely correct. I'm looking back at that original PSI, and the original PSI wasn't even agreed. It was a cap of 8 years in prison. And on that day, I gave you the opportunity for this probation. And you have had multiple, this is your third motion to revoke, so it hasn't all gone well. And the fact that you've been given those opportunities at SafeP twice and you're still doing what you're doing, I'm going to again so I'm finding count one true, find that you entered your pleas of true to counts 2 through 5 freely and voluntarily, find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. You're lucky that the agreement in this is for a cap of 5 years. You know, the cap went down from the original, which is usually doesn't happen. I'm going to follow this agreement, but you're very lucky. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you. You can go back with the bailiff. Excuse me, Johnny Segita, Mr. Rojas, it's a sentencing. Johnny. Mr. Lewis, you've got Avriana Dorsey, it's a sentencing.
This agrees with Mr. Brittman, and she was leading and everybody ran out on up to Richmond.
Oh, okay, I'll take care of that red hearing next. For Buddy, you're here on a red hearing for Buddy?
Oh, yes. Wait, no, about the way show. Yeah. Oh, no, even. Yeah, okay.
Good morning. Are you Avriana Dorsey? Yes, ma'am. And Ms. Dorsey was previously in court, entered a plea of guilty to burglary of a habitation, first degree felony. Have received the pre-sentence report. Have both of you had an opportunity to review that report?
I have Judge.
Yes, Your Honor, we have.
Any additions or corrections?
Nothing finished.
Not from the state judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. I also noticed in here that there was $450 in restitution that was requested. Did you
Yes.
have any other information about that?
Judge, I think that was just damage to the door and everything, when she came in, and we are asking that be added as payment of restitution.
I'm going to order that $450 in restitution as well. Ms. Dorsey, this is a great opportunity for you because you don't have a felony conviction on your record. This is a very serious offense. And so if you do everything you're supposed to, when you complete the probation successfully, the case will be dismissed. You'll never be a convicted felon. The other side of that, though, is extremely serious because if you violate any condition of probation, you can be brought back into court, found guilty, and sent to prison for between a minimum of 5 years up to 99 years of the rest of your life. Do you understand? ISF is meant to help you make better thinking decisions and things like that. So please take advantage of that program. Listen, learn, so that when you get out, you'll be successful. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you.
Hey.
Let's Marcus Elam.
Yes, ma'am.
And Mr. Elam is charged in cause number 26 DCCR 1221 with the first degree felony offense of murder. And Mr. Reynolds was appointed to represent Mr. Elam. Ms. Holmes has stepped in while Mr. Reynolds is out for some time and has filed a motion asking that I reduce bond in Mr. Elam's case, which is currently set at 1.5 million. Is that correct? Is it his is 2?
Yes.
Okay. And this is the co-defendant to the Mr. Blunt that I previously handled earlier today. All right, so let me just ask the state with regard to what I did on the previous one, is there any reason that this one should be treated any differently?
And judicial economy and all fairness, Judge, I think it would be appropriate to set both bonds at the same.
Okay, I will let you put some information on if you need or some evidence. I did grant the previous motion on Mr. Blunt's case and reduce the bond in that case to $1 million with the GPS and house arrest. I'm willing to do that based on the same information, unless you have something very different to point out about Mr. Elam, other than just he can't make the big bond.
Right, that's it. And just as far as where he would be staying, his mother resides in Humble. And that's the home that he would like to go to.
Which I wouldn't be opposed to at all, honestly. I mean, I think that would be better to have him maybe not as close to co-defendant and other things going on here. Would you have any issue if he's got a
That they
GPS?
Not be allowed to have contact with each other.
For sure. So, I need to make sure in that other order on Mr. Blunt that I write in, on that order. No contact with, DeMarcus Elam. So what I'm gonna do then, Mr. Elam, is I'm gonna grant the motion. I'm going to reduce your bond to $1 million. Condition of that bond is you have absolutely no contact or communication with Mr. Blunt. I know you guys are incarcerated here together. I want to make sure their dates are on different dates in the future if they're still in custody, so that they're not back there together. Also, a condition of your bond will be that you will be on house arrest and have to wear a GPS monitoring device. You'll have to give that address. I'm not making it where it has to be in Jefferson County. So if you make that bond, you can go. I want it to be within Harris County or Jefferson County. You can't just go anywhere, but I will allow you to go live with your mom in Baytown, and you'd have to give that address to your bondsman.
Well, that could
Humble.
be
I'm
Montgomery
sorry.
County,
Is
not
it Montgomery?
It's still Harris County.
It is. Okay. Whatever county it is in Humble with your mom, I will approve. Okay. If for some reason she moves somewhere different, you're going to have to get with your attorney and get with the bondsman so that I know where you are. And because we're going to be watching that GPS if you make that bond. Okay. All right. You can go back with the bailiff. Okay. Good morning, sir.
Morning, ma'am.
Are you John Gray?
Yes, ma'am.
And this is cause number 25 DCCR 1396, Ms. Molfino.
Judge, we have extended an offer of deferred probation in this case, which the defendant has accepted. I wanted the court to know that I have been made aware yesterday, actually, of the fact that he is also being investigated by Harris County detectives for the same type of offense. This is an impersonation involving some labor law issues and posters, etc. He was here on bond originally. I think he tested positive, if I recall, and that's why he's been in custody. It was my position to offer that same probated term. I reached out to Detective Williamson yesterday. He agreed with that, but just wanted the court to know those things are in the works. If you see him in the PSI, and that would be the reason for the state's position to be that we oppose a bond, even though it's a deferred probation.
Okay, thank you. And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Gray, you're charged with the third-degree felony offense of impersonating a public servant from July 14th of 2025. And how do you plead to that charge?
That's good.
There's no, I guess, guilty. Either you did it or you didn't do it. Are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine and any other conditions that would be ordered, especially after a PSI, and I see any and all issues that are going on. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Gray is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. So the probation department can do a pre-sentence report and that'll give us more information about you and your case, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Just count one, the first degree, or
Count one, the lesser included.
Listen.
We weren't sure which one to mark, so we went both.
okay, lesser included of
Rob.
Right. And he will have a hold from Liberty County and proceed there.
and this, it'll be the second degree.
Yes.
Yes.
All right, so are you David Hale?
Yes.
And Mr. Lewis, will your client waive the formal reading of the indictment?
Yes, Judge.
Mr. Hale, in cause number 26 DCCR 0106, the state has elected to proceed on count one only. And in that count, to the lesser included offense of a second degree felony robbery from December 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1.
Yes.
Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tender number 1,
No objection.
it's admitted. Is there any evidence that Mr. Hale's not competent?
No objection.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser included offense in count 1 freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the second degree felony offense of robbery. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir.
Thank you.
Good morning. Are you Angela Reyes?
Yes, ma'am.
And this is clause numbers 26 DCCR 0265, 0787, and 0788. Ms. Reyes was previously in court, entered pleas of guilty in those 3 cases. And I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yeah, Judge.
Yes, Your Honor. Yeah.
Any additions or corrections?
No defense.
No, Your Honor.
All right, Ms. Reyes, I'm going to find that you previously entered your plea of guilty in each of these cases freely and voluntarily. In cause number 26 DCCR 0265, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation, and I'll go over some of those in just a minute. And cause number 26 DCCR 0787, find sufficient evidence to find you guilty. However, I'm also going to follow the agreement that you made and defer all proceedings and place you on probation for 10 years in that case. Same thing, you'll have a $1,000 fine and be required to follow all of the rules and conditions of probation. Actually, hold on, there's only a fine in 26 DCCR 0265. There's not one in 0787. And then in 26 DCCR 0788, also find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation in that case. Part of those rules and conditions are that you're going to be on the mental health initiative caseload, and that's to give you whatever help you need so that you can be successful. The important thing about that is if they say that you need counseling or medication or whatever it is, whether you feel like you need it or not, it's going to be ordered that you do it, okay, for your benefit. And if you do everything that you're supposed to while you're on this probation, this is a great, great opportunity for you. You don't have a felony conviction on your record. You'll be able to finish this without any issues, and the cases will be dismissed hopefully at the end if you are successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. In 2 of your cases, you could be revoked and sent to prison for 2 to 10 years. And in the other case, you could go to prison for 2 to up to 20 years. Do you understand?
Yes.
I will sign dismissals and all of the other pending cases as part of this agreement. I'm going to hand you, in these cases, the trial court certifications that shows that these are agreements that I followed, and so you've waived your right to appeal.
Yes.
Good luck to you, ma'am.
Thank you.
Obviously, if anything else comes up, we can add, but did you find any? I just realized that at the very first sentence,
They didn't have the offense in there.
I just changed that. Is there anything else that either of you,
They're very vague. I think we got this issue in the last trial, page 4, that the paragraph begins with under the law applicable. That last sentence.
Oh,
second to last
yes.
sentence, I don't know that we need that in there.
you're right. I'm
Talks
taking
about
that.
less than 4 years.
The next to the last sentence I'm taking out because it's just confusing. You see that, Chip?
Yes, ma'am. But the eligibility for parole does not guarantee parole. That.
And I think that makes.
Yeah.
Somebody's.
Y'all hang on just a second.
And that you have.
Thank you.
And I'm advising you that you not testify if you remain silent.
Thought about that.
Judge, I just need to put his assertion of his Fifth Amendment right on the record.
Okay,
Just
hold on.
clear, Judge, you're leaving in that last sentence, it says eligibility for parole does not guarantee parole is granted.
Yes.
That's all I have. It seems, am I missing something? It seems a little short, like, is it because we don't have probation in there?
There's no probation, there's no
Yes.
enhancement
Okay.
and things like that, to find priors true and all that kind of stuff. That's usually what makes them long. A standard, we don't have them very often, but they're very short. I think everything's in there. With regard to the charge, Mr. Rafford, anything? Right.
Nothing we hadn't argued with.
All right, and so you need to put something on the record?
Yes, ma'am.
Go ahead, sir.
Mr. Freeman, you understand again that you have a right to testify
Yes, sir.
in the punishment phase of the trial. I'm advising you that you should not testify at this phase of the trial. Do you agree with that?
Yes, sir.
All right, that's all I have, Judge.
Thank you. And was there any issue you guys had come to the back with regard to some potential?
He showed me it's innocuous, Judge. I don't have a problem.
Okay, perfect. Thank you. And Mr. Coleman, I'm going to need your signature on this discovery certification. Please, sir. All right, then. Anything else before? Thank you, sir. Anything else before we bring the jury in?
No, ma'am.
All right, we can bring the jury in, please. I need the witness in. Is it in? It should be on the waiting list. There it comes. I think you've got to click it.
Very good. And did you in fact bring some records with you today?
Yes,
Those records, who do they pertain to?
they pertain to Mr. Joseph Freeman.
And how did they come into the possession of the Jefferson County? Or how were they generated by the Jefferson County District Attorney, Jefferson County Sheriff's Department?
They're created through the routine intake process. Anytime somebody comes in, it's files we generate whenever they're brought into custody.
And when you say coming in, you mean when they're arrested, right?
Yes,
And when someone is arrested or quote unquote booked into the jail, certain information related to that individual is gathered and maintained by the sheriff's department, right?
yes.
That information includes what?
Name, date of birth, driver's license number, state ID number if they have one, fingerprints, mugshots.
And you brought with you here today those types of identifying information for an individual named Joseph Freeman, right?
Yes, sir.
May I approach the witness, Judge?
Yes.
Take a look at those documents, please. I'm going to hand you what I've pre-marked as State's Exhibit number 85. Are those are 8 pages of documents. Are those true and accurate copies of the documents? Other than the redactions that we made for trial today, are they true and correct copies of the documents maintained by the sheriff department as it relates to an individual by the name of Joseph Charles Freeman?
Yes, sir.
And you, as a custodian of record, by virtue of your employment, have access to those records, obviously, because you brought them with you, right?
Yes, sir.
And those records were created and maintained in the ordinary course of business for the sheriff's department, correct?
Yes, sir.
Your Honor, at this time, State Officer states 85, and they've been previously tendered to defense counsel, and I'll tender them to him again.
I don't have an objection, Judge.
States 85 is admitted.
Captain Ponder, let's just kind of run through States 85 there real quick. I guess what I'll do is I'll use the copy and you can keep that marked copy. That first page there, what are we looking at?
That is a fingerprint card from whenever Mr. Freeman was fingerprinted upon intake.
Okay, and the name that appears there in full, what's the name?
It's Joseph Charles Freeman Jr.
Okay, there is something there that's referred to as a state identification number, correct?
Yes, sir.
And in short, the people in the law enforcement community they also refer to it as a SID number.
Yes, sir.
And for the record, that SID number is what?
It is 1950332.
And is your understanding of the SID number or state identification number, do you understand it to be unique to each individual?
Yes, sir.
Okay. Not unlike a driver's license number or social security number. Right?
Yes, sir.
Is there a date of birth there that's reflected as well?
Yes.
What is that?
It is May 3rd, 2003.
And then we've got other information contained in these 8 pages, but is it fair to say essentially it is other identifiers or identification related to an individual by the name of Joseph Charles Freeman?
Yes, sir.
And I want to direct your attention to maybe the second to last page there, this page.
Yes, sir.
What is that?
That is a photo of Mr. Freeman.
Photo taking at the time of at least one booking or arrest?
Yes, sir.
Could you hold it up and show it to the jury? Do you see an individual in the courtroom here today that resembles that individual in that booking photo that you have just displayed to the jury?
Yes, sir.
Could you please point to him and identify him by an article of clothing that he's wearing?
It's a gentleman in the black jacket.
On my right here,
Yes, sir.
you're not asked if the record reflect the witnesses identified the defendant.
The record will so reflect.
I think those are all the questions I have for you, Captain Ponder. Thanks for being here today. Appreciate it.
One question.
Thank you, Mr. Bradford. Any objection to Captain Ponder being excused? Thank you, Captain. You're excused. You may call your next witness.
State calls Steve Hinton.
And Investigator Hinton is still under oath from before. You can have a seat, sir.
Yes, ma'am. Investigator Hinton, would you please state your full name for the record? Stephen Hinton. And the jury will recall you from your prior testimony and your role with the district attorney's office as an investigator. In addition to being an investigator, are you also trained with regard to fingerprints? Yes, sir. And when someone receives a conviction and it's memorialized in what we call a judgment, oftentimes does that come with a fingerprint?
Yes, sir, they do. Normally the right thumb.
But that's not always the case, right?
Yeah, it's not always the case, depending on the rural areas where it may came from and then the quality of the print itself.
That was my next question. Even if sometimes those judgments have a print on them, they're not always, the quality is not the best, right?
That's correct.
And why would,
That's- Can you pull that microphone down and speak a little bit? Thank you.
thank
Go
you,
ahead.
Judge. And why would that matter to you or in this context?
I think the goal and the objective is to look at prior convictions and compare the prints to determine that it is and it does belong to the defendant in this case, so that nothing is interjected in there that would not belong to him.
Okay.
That's protection for him.
Now, the prints are not the only way, the allowable way to essentially link a judgment or prior conviction to an individual, right?
No, it's not.
What are some or what are other ways that an individual can be linked to a previous conviction?
You can use an individual's name. You can use a state identification number issued by the Department of Public Safety. You can use a date of birth to still continue to cross-reference and verify that it is one and the same.
Very good. Let's go back to the fingerprint. The jurors, I'm sure, have a notion based on their life experience and what they may have seen on TV about what a fingerprint consists of. But in your training and experience, what is a fingerprint?
It's scientifically speaking, it's friction-ridged skin. It appears on your fingertips, on the palms of your hands, and it's also on the sole of your feet.
And is it unique? Are those prints unique to each individual?
They are. They're very unique and distinct per individual. No one's ever been found to have the same print.
And are you able to take an inked print and compare it to a print that's on a judgment?
I am, yes.
In fact, did you take an inked print of this defendant in this case?
I did.
What is an inked print for the benefit of the jury?
It's where you apply an ink type substance on the friction-rich skin itself, and then you would roll it or you would stamp it on the paper so you could compare it to whatever the, in this case, previous convictions or judgments. You can compare it to the prints that are on those documents.
Did you bring that inked print with you today?
I did, yes, sir.
May I approach the witness? Judge?
Yes, sir.
I got ahead of myself. Once. Something out of order here. Your Honor, I'm gonna be out of order on my evidence on my exhibit labels here,
That's
but
okay.
I'll work it. I'll come back around. I am marking this as state's exhibit number 89, and I'll go back to 86, 87, 88 later. When did you obtain this inked print from the defendant?
It was about 12 o'clock, 12:15. Today.
Does it appear to be in the same condition as it was when you first obtained those inked prints?
Yes, I got the date and then my initials on it. I put the defendant's name, SID number, date of birth on there so it wouldn't get mixed up with any other prints.
And it doesn't appear to have been altered or manipulated in any way?
No, sir.
State Officer States 89, judgment tenure to defense counsel.
No objections.
89 submitted.
Investigator Hinton, what did you do with state's exhibit number 89 after you obtained it?
I compared them to the 10 finger packet from the county jail and verify that they are one and the same. And then I started looking at the documents itself, prior judgments to compare the prints.
The 10 finger packet that you're referring to, would that be the documents that were brought over by Captain Ponder that that are now in evidence marked as state's exhibit number 85?
It appears to be from this distance, yes.
I'm having very closer. May I approach those?
Yes, sir.
Yes, sir, that's it.
Okay, and so just to be clear, you've compared your inked prints to the prints on file with the sheriff's department, and what, if any, determination did you make?
That they were one and the same. The SID numbers match, the date of birth match, the names match.
Okay, so once you've taken your inked prints in states 89 and compared them to the known prints in states 85 from the sheriff's department, what did you do with that information then?
Then I started to compare those with the judgment documents that are provided.
And did you obtain or come into possession of certain prior judgments that you believe belong to this defendant?
Yes, sir.
And you compared those prints to those documents?
That's correct.
I'll show you what I've marked as states exhibits number 86, 87, and 88. And I'll ask you if those are the judgments that you're talking about.
Yes, sir. It's all three of them.
All right, let's start with well, I guess we need to admit them. Your Honor, at this time, do this. Yeah. Well, I'll admit states or offer states 87, 88, 86, excuse me, 87 and 88 as certified documents, Judge, and I'm tendering the defense counsel for his inspection.
Absolutely, pardon.
Yes.
Objection.
86, 87, and 88 are admitted.
Let's start with 88, please, investigator Hinton. Well, you got a copy of it there, right?
I do. I don't know which exhibit they are, but
88
I
is
can mark them.
this cause number.
Greater than 8.
And then 86 is this cause number.
6.
And of course, 87 will be the last one. If we could, I can direct your attention to states 88. What type of offense are we looking at there?
That's going to be evading arrest in a motor vehicle.
Is that a misdemeanor or a felony offense in the state of Texas?
That's a felony offense, 3rd-degree felony.
And what is the cause number on that particular judgment?
Cause number is F22-3098-462.
And what county is that out of?
That's going to be in the 462nd District Court of Denton County, Texas.
Okay. And what was the disposition in that particular case?
Guilty.
And was the defendant, I guess what I'm getting at is, at least according to the judgment, was the defendant sent to prison or was the defendant placed on probation?
He was placed on 3 years deferred probation and $500 fine.
And I think I got a little bit ahead of myself. I did not exactly ask you whether or not you were able to use the fingerprint from that judgment to link it to this defendant.
Right, use that one again to make sure that's the print. Yes, I used this print. It exhibited very unique deltas. There's one on both sides of the core, and there was 3 other ending ridges, which are identical to the known print that I took. And because of the pixelation of this one, that's the only, so it's total 6, 5.
So unpack that a little bit. I mean, during your training experience, what are you looking for when you're comparing prints? You mentioned deltas and ridges. Explain to the jury what you're looking for.
I'm looking for characteristics. Some people call them points, is where they occupy on a known print, where they occupy the same space that they would occupy in a different print. So you can make the comparison between the two, determine if they're one and the same.
I mean, this is not just like throwing a dart at a dartboard. I mean, there is an art or a science, right?
There is, yes.
To doing this, correct?
Absolutely.
And is that method that you are trained in and that you used in this case, is that method widely accepted and used by law enforcement throughout the country?
It is, yes.
And did you use any special equipment to help enhance or magnify these prints so that you can make the comparison?
We do have magnifiers to be able to pull them up so they can be more readily visible.
And is it your testimony here today that you found sufficient enough points or ridges, or what was the other term you used?
There was 2 deltas, one on each side of the core, and there was 3 ending ridges. But because of the pixelation of this particular one, that's the only 5 that I'm really comfortable with identifying. That in conjunction, of course, with the SID, the state identification number and the name.
So for that felony offense of evading arrest, out of Denton County, for which the defendant received probation, you are comfortable that it's linked to this defendant, Joseph Charles Freeman, by virtue of his fingerprint on that?
Yes, sir.
What was the date? What would have been the date that he received that 3 years of deferred adjudication probation?
Date of offense was 7/28 of 2022.
So he would have been on probation, given that offense date. Well, do you have a judgment date when he received the probation? It may say sentence date on the first.
It showed date proceedings was deferred on October 27th, 2022.
So October of 2022. And you understand that the offense date for this particular case is in March of 2022, March 27th of 2022, more specifically.
Yes.
Okay. Let's move on to State's Exhibit number 86. What type of offense is that we're dealing with?
This is going to be a judgment of conviction by the court for aggravated robbery.
In your law enforcement training experience, typically, what is an aggravated robbery?
Aggravated usually means that there was a device used that is capable of committing serious bodily injury or death.
And in this case, if you look about midway down that first page of the judgment, does it indicate whether or not a deadly weapon was used and the type of deadly weapon?
Yeah, it shows the findings on deadly weapon as yes, there was a firearm used in this particular offense.
Well, at least according to this aggravated robbery judgment, the individual convicted of this offense used a firearm in the commission of that offense. Correct?
That's correct.
All right, let's work our way down through this. What is the cause number on that one, please?
Cause number is going to be F22-39679-0.
Out of what county, please?
That's going to be in Jefferson County and 252nd District Court.
Now, this particular judgment does not have a usable fingerprint on it, right?
No, it does not.
So how were you able to link this, if you were able to link it to this defendant, how were you able to do so?
With the name and the SID number, state identification number.
So the name that appears on here is Joseph Charles Freeman, right?
Correct.
And the state ID number, what is that, please?
It's a number,
No, I think they already got that from Captain Ponder, what it is, the type number. What I'm getting at is what's the actual number on the judgment. Please.
Oh, I got you. State ID number is 195-03322.
Does that state ID number match the SID number on the booking records?
It does.
Does it match the SID number on that evading arrest probation order that you were able to confirm the fingerprint on?
It does.
Okay. Let's work our way down through this a little bit more. What's shown to be the date of offense on this one?
Shows March 19th, 2022.
So it would have preceded the March 27th, 2022 offense date in this case by a few days, right?
That's correct.
What was the sentence in that particular reflected in that judgment?
The sentence was for 60 years in the institutional division of the Texas Department of Criminal Justice.
60 years in prison.
60, yes, sir.
Let's move on to State's Exhibit number 87, please. State's Exhibit number 87. Let's just kind of shorten this a little bit. Is it fair to say it's for the same type of offense, aggravated robbery?
It's for this aggravated robbery, yes, sir. Committed on the same day.
Committed on the same day.
Second
And
robbery, yes.
And it's out of the same court, the 252nd District Court of Jefferson County, right?
That is correct.
And it is likewise for a 60-year sentence as well, right?
It is, yes.
And did you use the SID number to connect it to this defendant as well?
That's correct.
Again, because there was no usable print connected to this.
On this one, yes.
Now, based on your training and your law enforcement experience, if there is two separate judgments with two separate cause numbers from the same day with the same concurrent prison sentence, what does that tell you?
That's two separate events,
Or at least two separate
offenses.
well, I kind of stepped in, at least two separate instances or two separate victims, right?
Correct.
Okay.
Cause number on exhibit 87 is going to be F22-40981-0.
Thanks for making sure I put that, you put that on the record. I appreciate that. Let me gather up these exhibits, and I think that's gonna be all the questions I have for you. I'll pass the witness to you.
Thank you, Mr. Coleman. Mr. Bradford?
Mr. Hinton, I just have one question.
Yes, sir.
May I approach?
Yes, ma'am.
These judgment and sentences, those represent pleas of guilty, don't they? And they're not jury trials.
They are. They're all pleas of guilty. Yes.
That's all I have.
Any other questions, Mr. Coleman?
No, Judge.
Any objection to Investigator Hinton being excused?
No, yeah.
No, ma'am.
Thank you, sir.
Stay rest at this time, Judge.
Thank you, Mr. Coleman. Mr. Radford?
Bench rest.
All right, so ladies and gentlemen, what that means is that you've heard now the evidence that'll be presented on punishment. And next thing to do is the court's charge and closing argument. Mr. Coleman and Mr. Radford, everybody's had an opportunity to go over that charge. No issues or objections, or are we good now with it?
Yes, no objections.
No objection, Judge.
All right, is everybody ready to go forward?
Yes, sir.
All right, so at this time, ladies and gentlemen, I'm going to read the court's charge. Cause number 24, DCCR 0348. The state of Texas versus Joseph Charles Freeman, jury instructions. Members of the jury, you have found the defendant, Joseph Charles Freeman, guilty of the offense of murder. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will tell you about the specific law applicable in this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you've been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide the punishment by lot or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the juror thinks should be served. These are then added and the result is divided by 12. To reach a verdict, all 12 of you must agree. Rules that control deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. The foreperson should conduct the deliberations in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. 3, you must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. And 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Specific law applicable to this case. You have found the defendant, Joseph Charles Freeman, guilty of murder. Relevant statutes. This offense is punishable by 1, a term of imprisonment for no less than 5 years and no more than 99 years or for life, or 2, a term of imprisonment for no less than 5 years and no more than 99 years or for life and a fine of no more than $10,000. Parole. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if he's sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. I think it is missing something that you mentioned now that I'm looking at it. Y'all give me just a second. Let me look at something. Sorry. Every time. The application paragraph. Right, should it have an application or does it enough to have the relevant statutes? Act like I haven't done this 14 times this year.
We're not looking at a previous one that I heard.
Hold on, I'm gonna get there. No, I think it's it. That's all it shows. We're good. Yeah, okay. So then the last page is the verdict form. And you have, well, it reads, we, the jury, having found the defendant, Joseph Charles Freeman, guilty of the offense of murder, assess his punishment at, and then there's 4 options and you'll select one option. The first option is imprisonment in the Texas Department of Criminal Justice for a term of, and it's 5 to 99 years and no fine. The second is imprisonment in the Texas Department of Criminal Justice for a term of blank, 5 to 99 years, and a fine of blank, $10,000 or less. The third is imprisonment in the Texas Department of Criminal Justice for life and no fine. And then the final one is imprisonment in the Texas Department of Criminal Justice for life and a fine of blank, $10,000 or less. And then there's a line for the signature and the printed name of the foreperson. Mr. Coleman, you have the right to open and close, closing argument.
It waives the right to open, but reserves the right to close.
Thank you, Mr. Coleman. Mr. Radford, you may proceed. Attorneys present, defendant and defense counsel are present. The jury has sent a note that they've reached a verdict. You can bring the jury in, please. Let the record reflect the jury seated, state's attorneys present, defendant, and defense counsel are present. At this time, I'd ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes.
Thank you, sir. You can hand it to the bailiff. Redford, Freeman. We, the jury, having found the defendant, Joseph Charles Freeman, guilty of the offense of murder, assess his punishment at imprisonment in the Texas Department of Criminal Justice for a term of 60 years and no fine. You can have a seat. Does either party wish to have the jury polled?
Your Honor, the state does not, and I would withdraw my motion to accumulate sentences.
Thank you, sir. Do you wish to have the jury polled?
No, ma'am.
Is there any reason at this time not to pronounce sentencing?
No.
Sentence. Right, then at this time, Mr. Freeman, in conformity with the jury's verdict, I sentence you to a term of 60 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You've been handed 2 documents. The first is the trial court certification of your right to appeal. Mr. Radford will go over with that and explain what your rights to appeal are. The second is a written admonishment regarding your ineligibility to possess a firearm or ammunition. We've gone through this before. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right. So at this time, you will be remanded to the custody of the Jefferson County Sheriff's Office until transportation to the Texas Department of Criminal Justice. And so I'm going to go ahead and have the bailiff bring Mr. Freeman back. Ladies and gentlemen, I'll come visit with you in just a minute and discharge you all from everything in just a second. Thank you, Mr. Coleman. Thank you, Mr. Radford. And court will be adjourned, and we'll have you guys exit the courtroom, please.
Imagine standing before a judge after spending nearly a decade on probation, knowing one decision could determine whether you walk free or head to prison. That's exactly what happened during this emotional courtroom hearing involving Byron Jamal Morris, whose probation was once again under review. The hearing began with the judge reviewing an updated pre-sentence investigation report. Morris had originally denied committing a new offense of public intoxication, but he admitted violating another condition of his probation by consuming alcohol. The judge accepted that admission and changed his plea on that violation to true. However, the more serious question remained whether Morris had committed the new offense of public intoxication. To prove that allegation, prosecutors called Officer Michael Jansen to testify. The officer explained that he responded to a late-night dispatch at a Swift gas station after reports of a man sleeping at a gaming machine. When officers arrived, they found Morris asleep and said they struggled to wake him, first by speaking to him and then by using physical stimulation. According to the officer, Morris eventually woke up, but he smelled strongly of alcohol, had bloodshot eyes, and displayed an unsteady walk. Based on those observations, the officer concluded that Morris was intoxicated. The prosecution then asked why the officer believed Morris was a danger to himself. The officer explained that the gas station was located in what he described as a high-crime area. Because Morris was asleep and difficult to wake, the officer believed he could have been robbed, assaulted, or become the victim of another crime if left there unattended. During cross-examination, the defense challenged that conclusion. The attorney pointed out that officers were not responding to reports of violence or fighting. He also noted that once Morris woke up, he was not argumentative or disruptive. The defense further questioned whether Morris's condition could have been caused by something other than alcohol, including the possibility of a seizure. While the officer acknowledged seizures as a possibility, he maintained that intoxication remained his opinion based on the circumstances he observed. Morris then took the witness.
Imagine standing before a judge after spending nearly a decade on probation, knowing one decision could determine whether you walk free or head to prison. That's exactly what happened during this emotional courtroom hearing involving Byron Jamal Morris, whose probation was once again under review. The hearing began with the judge reviewing an updated pre-sentence investigation report. Morris had originally denied committing a new offense of public intoxication, but he admitted violating another condition of his probation by consuming alcohol. The judge accepted that admission and changed his plea on that violation to true. However, the more serious question remained whether Morris had committed the new offense of public intoxication. To prove that allegation, prosecutors called Officer Michael Jansen to testify. The officer explained that he responded to a late-night dispatch at a Swift gas station after reports of a man sleeping at a gaming machine. When officers arrived, they found Morris asleep and said they struggled to wake him, first by speaking to him and then by using physical stimulation. According to the officer, Morris eventually woke up, but he smelled strongly of alcohol, had bloodshot eyes, and displayed an unsteady walk. Based on those observations, the officer concluded that Morris was intoxicated. The prosecution then asked why the officer believed Morris was a danger to himself. The officer explained that the gas station was located in what he described as a high-crime area. Because Morris was asleep and difficult to wake, the officer believed he could have been robbed, assaulted, or become the victim of another crime if left there unattended.
And that's how the gavel fell today. Case after case, story after story, all under one roof, all decided in the span of a single morning. From Byron Morris, whose decade on probation finally ran out of second chances, to Joseph Freeman, who now carries a 60-year sentence for a crime that changed lives forever. What you just watched isn't scripted drama. It's the real machinery of the justice system. Plea deals negotiated in hushed tones. Fingerprints compared point by point. Officers recounting the smallest details from memory. And judges weighing years of a person's life in the space of a few sentences. Behind every case number is a human being, a family, a victim, and a judge trying to balance the law with whatever humanity the moment allows. Some walked out with probation and a second chance. Others didn't. Some pleaded guilty because it was true. Others fought until the evidence spoke for them. That's the reality of a courtroom. It's rarely simple, and it's never just paperwork. If this kind of raw, unfiltered look into the courtroom keeps you coming back, make sure you're subscribed, because dockets like this one play out every single day, and we'll keep bringing you the ones that matter. Drop a comment below. Which case stood out to you the most? Morris and his years of chances? Freeman and the weight of that verdict? Let us know. And if you haven't already, hit that like button. Share this with someone who's into true crime and courtroom footage, and turn on notifications so you never miss the next hearing. Thanks for watching. We'll see you in the next one.